Okay. Go in the waiting room. All right. Another 30 seconds. We'll get started. And I'm not running the attendance today, so don't worry about signing in. All right. Any question? Oh, I'm sorry. I'm on mute. I apologize. Thank you, Colin, for that. Any questions before we get started? No? No. While I was on mute, I said there's no attendance today, so that's what I was saying. So I apologize. Thanks, Laura. Yeah, no, it's a makeup day. I don't feel right taking attendance when it's not your regularly scheduled class, so there's no attendance. Although I do want to do a policy for next semester. So I've noticed that just coincidentally, when people are likely to be called on, they're more likely to be absent. I've gone through the numbers. It's true. Consistently, when I'm at a certain letter in the alphabet, there's like 4 or 5 absent, and those are the only absent people. Surprise, surprise. So next year, what I'm going to have to do is a policy where if you miss class, you are automatically on call the next class. So I will start every class with those who are absent. So that will, I think, help to eliminate the rest. So really, there are 2 things I'll do differently next year. First, if you mark yourself present and I happen to call on you and you're not there, you're absent. And second, if you are absent, you're up first next class. So I'll just take a brief detour. I think that will eliminate some of the incentives. Students are very good. Students are very good at evading being called on, even though it's to their own detriment. I didn't have that problem as much in class in person, but on Zoom it's a lot easier. I think, at least. Okay. So yep, you're up first. I mean, if you're in First Amendment, it'll be you. But I think with First Amendment, you want to be in my class. You're there voluntarily, whereas here you're really not. You don't. So people have choices, and usually I find with the upper level classes, people want to be there and usually more responsive. Okay. What else? Anything else in your minds? All right. I'm going to have office hours today. Immediately, not immediately, but at 12:30. So a few minutes after class finish, I have to give me a little break. So at 12:30, after class begins, I'll have office hours. I'll have a queue, and you're welcome to join. If you have anything you want to ask me, you're welcome to ask me. Our review session is going to be on, I think it's the 6th, right? Yeah, I think I said the 6th. And so if you have other questions, you can bring questions to that as well. Or if you want to meet with me during the week, email me, and I'm sure we can set up a time. Zoom makes it very easy to set up a 15-minute call. It's not hard. I can be flexible. All right. Anything else? Okay. All right. So today is our last class, which is scary to even think about, but it's our very last class. And I want to finish up our last class with a discussion of both equal protection and substantive due process. Right. This is really the core of our second half of the semester. Right. We have equal protection, due process. And the cases today implicate both of these concepts. Okay. So let's just review big picture here. Over the last, 60 or 70 years, the court has recognized that different types of classifications are reviewed in different fashions for purposes of the Equal Protection Clause. When the government imposes what are called suspect classifications, for example, when they separate people by race, the courts are suspicious. And the courts review racial classifications strictly, with strict scrutiny, where you need the compelling state interest and you need to have narrow tailoring. Most other classifications were reviewed deferentially, that is, with a rational basis standard. So age is a classic example. In the 1970s, the court began to carve out a middle tier, what's known as intermediate scrutiny, which means that there can be some kinds of sex-based classifications, but the government must show a very important interest to do so. And they have to have a good relationship between the means and the end, substantial relationship. There are other cases that I did not have the ability to sign this semester because I ran out of time, but they're referenced in a reading today, and I want to talk about them. They are fair game. In the 1980s and 90s, the court had a few cases which suggested, well, generally, if you have a non-suspect classification, you might use a rational basis standard. But there might be some other types of non-suspect classifications that still warrant a closer look. And these cases became known as rational basis plus or rational basis with bite, right? The notion that in certain cases, the court's more skeptical. Now, the court didn't recognize additional suspect classifications. They simply just carved out basically was a fourth tier in our now very messy layered cake. You have strict scrutiny, you have your intermediate scrutiny, you have this rational basis plus, and then you have rational basis. Now, students at this point are getting confused, right? It's like, what the hell's going on, Josh? We have this really neat 2 thing, then there's 3 things, okay, now there's 4. What gives? And the court never explained what it was doing. It sort of decided each case one at a time. And I blame one person for this. I blame Justice Kennedy. I don't say it lightly, but he didn't care about doctrine. He didn't care about tiers of scrutiny. It was never important to him. That was never a concern for him, how you fit things into doctrine. He didn't care about it, which you might like the results, but law students hate it because they can't learn anything from it. But in the 90s, the court seems to suggest that maybe there was this fourth tier. And a lot of people wondered, was a person's sexual orientation, whether they were a gay or lesbian person, right? Was that a classification like gender? Or is that a classification like age? Or is it somewhere in the middle? Right? And throughout the 90s, this wasn't clear. The court just didn't give us guidance on this issue. Right? Some lower courts began to suggest that a sexual orientation classification should be viewed the same way sex-based classifications were, which I think is where the court will probably come out today, given Justice Gorsuch's view, but not sure. But we didn't know. Okay, so that's the equal protection component of doctrine of the last 70 years. Then we have the due process component. Our study of due process began in the early 1900s with Lochner, right? Whether you have this unenumerated right to contract. And that view prevailed for some years, but then we get to the 30s, into the 40s, where the court rejected these sorts of unenumerated rights. We have Caroline Products footnote 4, where they said we're not going to start making up these rights and imposing our value judgments. But then some years later, we get to the Griswold case with contraception, and we have the penumbras and the emanations, and we have the due process clause with all these liberty interests, and then we have Roe, and the court suddenly does recognize this right of privacy that's not written down. There was a backlash, though. In the later 70s and early 80s, the court began to separate rights. And the court said if a right was so-called fundamental, right, an unenumerated right was fundamental, the court would review burdens on those rights strictly. Right? So if you have a fundamental right, that fundamental right triggers strict scrutiny. Right? The court would be very skeptical if the government tries to burden a fundamental right. If it's a non-fundamental right, then you review the law with a rational basis review, and it's upheld. Now, Josh, you're asking, what's a fundamental right? The court never really gave a clear definition of what a fundamental right was, but there are certain guidance or certain guidelines they focused on. It was a historical test. For example, was a right deeply rooted in history? Right? Was this a right that's been around for so long that people can't even question it? The upshot of this historical test is that new rights that sort of popped up in the last few years would not be deemed fundamental. And this deeply rooted right led to a case called Bowers v. Hardwick, Bowers, Bowers v. Hardwick, Hardwick, Hardwick. I didn't assign it because I don't have time, but it's discussed in Lawrence, so you should read about it there. And the question in Bowers was whether there was a right under the Due Process Clause to engage in same-sex relations, homosexual sodomy, as they call it. And the court said absolutely not. Justice White wrote the majority opinion. He said this is ridiculous. Society's been banning sodomy for over a century, and indeed even longer. How can you claim there's a deeply rooted right to engage in sexual relations if this has long been banned as an activity? All right. So that brings us to, 2003. You have some hints, some suggestions that sexual orientation might be a classification that's somewhere above rational basis review, but we don't really know where that is. And you have the precedent of Bowers, which suggested that the right to engage in sexual relations with a person of your same sex is not a fundamental right. All right, so those are the two precedents leading up to Lawrence in 2003, right? That's where the world was. I remember 2003. I think I guess it was a freshman or sophomore in college. I remember when Lawrence was decided, and it was a huge deal at the time. I remember just a lot of people were. It was a huge issue at the time. We're only 17 years from Lawrence, but I think most of you probably don't really remember how controversial the gay marriage issue was. In 2004, a number of states put amendments on the ballot, Texas included, to prohibit gay marriage. I think Texas passed by 75%, some really large number. And politicians across the country ran on the platform of basically banning gay marriage. Today, I think just that movement has just fizzled in ways that I did not anticipate happening in this fashion. It happened really quickly. I mean, it's been a decade. Views changed, which doesn't happen very often. It's happened on same-sex marriage far quicker than it did on race, I'll tell you that much. It's just the parallel is just so different. Just the trajectory. Just think of, Loving versus Virginia was in 1968 or 69, and then you have Obergefell, a decade after Lawrence. So just the change in views just was frankly stunning. How quickly it happened. All right. Okay. So that brings us to 2003, and then we get to Lawrence v. Texas, which is a Houston case, and it's even worse. It's a South Texas case. The prosecutor who prosecuted the case, the Harris County DA, is a South Texas alum. He did not do a good job. He litigated this case because he thought it would help his political career. He thought that this was a winning issue for him. It would put him on the map and get him a lot of credit among social conservatives. At the time, the Texas Attorney General pleaded with him, please don't bring this case to the Supreme Court. Don't litigate this case. Don't do it, right? Don't appeal this case, right? Just let this case go, dismiss it. Don't litigate this case. Because the Texas AG worried, actually I think it was Greg Abbott at the time, worried that this would set a precedent that would lead far beyond a sodomy statute that was really never enforced. But he ignored them. And he argued the case for the Supreme Court. His name is Chuck Rosenthal, by the way, who he randomly emails me. It's kind of awkward. I'm always talking really bad about him in class, about his poor performance, but he doesn't know that. I don't know. But he emails me every now and then. He's a nice guy, but just his argument was terrible. At one point, I think Justice Ginsburg asked him, does Texas allow gay parents to adopt? He's like, I don't know. Like he was completely unprepared, right? I'm not just saying he was a bad lawyer. He was, but he was unprepared for the job. He treated it as if he was arguing in like a Harris County District Court, not the U.S. Supreme Court. That's neither here nor there. Apparently not. Apparently he doesn't watch YouTube. I'm happy. If he sees it, I don't care. I say what I think. I don't really. In case you notice, I don't hide what I think. It's a blessing and a curse, I suppose. But it's true. He did not do a good job. Ted Cruz was our Solicitor General. He wanted to argue the case, or if Ted wasn't there, was his predecessor. It was very close when they switched, but Rosenthal insisted on arguing. If Ted would argue, it would have been much better. You may not like him as a senator, but he was a good lawyer. He was a very good lawyer back in the day. All right. So that's the setup for Lawrence. And the way this case even happened is bizarre. And I have some of this in the video. If you watch the video, you have the interviews with Lawrence. I encourage you to watch it just to see it in his own words. He was just a regular guy living in Houston. He had I don't want to call it a boyfriend, because I don't think they were in a relationship, but he had a partner. His name was Geddes, right? And they had a relationship. Exactly what they were doing wasn't clear. And so here's the setup, and this is how it's been told a few times, and I think the truth is somewhere in the middle. Here's how the story's been told. You have Lawrence that is also his boyfriend. Lawrence at his boyfriend's house, and the cops break in, and they see them engaging in sex. Although it's not really clear what they were doing, right? And if hopefully none of you are too squeamish, but one cop said he saw anal sex, another cop said he saw oral sex, and the other two weren't sure. It's very hard to confuse oral and anal sex. They just don't look alike. I'll leave it there. This is a G-rated, actually, no, it's an R-rated program, but I'll just leave it there. All right. So according to Lawrence, and this is what my best guess is, they probably were not clothed, but they also weren't engaging in any sort of acts. Those were just whatever. But they were arrested and they were charged with violating the Texas sodomy statute. Now, the Texas sodomy statute was really never enforced. It had never been enforced in years and years and years. At this point, the prosecutor should just drop the charges. He should not have pushed forward, but he did. And you had Lawrence plead basically what's called no contest. What does no contest mean? I said Geddes. I meant Lawrence. I'm sorry. I said Geddes. I just flipped in my head. No contest means you're not pleading guilty. You're not pleading innocent. You're saying, I don't dispute it, right? By pleading no contest, they could appeal the case. And that was what let them get the case to the court. Okay. Any questions so far? I think that's the back. There's a huge wind-up for that case. There's a lot of work to get there. Yes, Tori, go ahead.
Oh, but this was a test case, right?
Well, a test case, Tori, means you try to get arrested deliberately, right? Lawrence and Garner were not trying to get arrested. They did get arrested by complete, chance. And let me please give some more background. From what I've gathered, why did the cops even show up at Garner's apartment? There was a jealous boyfriend. Or at least, well, Cassie, that's partly correct. There was a jealous boyfriend. Garner's boyfriend, or maybe a lover, I don't know the exact details, was jealous that Garner's with Lawrence. So the boyfriend called the cops on Garner to Garner's house. And the claim basically was that there's a black guy with a gun. That was the claim. And the cops showed up. Garner was African American. And that's why the cops showed up at this house, right? It wasn't, please come to their house to arrest them, they're having sex. It's, there's a guy with a gun. And as best as I can tell, it was completely made up. And it was basically a jilted lover trying to get Garner in trouble. Which is insane if you think about it. Laney asked, was there a dispute with the cops having a warrant? I actually think this was a Fourth Amendment case. I don't think the cops had cause to enter. very often cops enter your house without permission. And this should have been a Fourth Amendment case, but they didn't raise that. They wanted this to be a 14th Amendment case. There was another case from the 1960s called Mapp v. Ohio. Did the casebook say that? What idiots wrote the casebook? No, I'm kidding. Yeah. I don't put everything in the casebook, I think. I put the neutral stuff, but I sometimes give you my opinion. There was a case in the 60s called Mapp v. Ohio. I'm sorry?
Your co-author must have inserted that comment.
Nah, it's all our joint product. We don't take over.
The amendment thing wasn't even an issue. It was all about.
Well, they didn't raise it. That's what means it's not an issue. They didn't raise it. They could have, but they didn't want it to be an issue. Right? That's what means it's not an issue. But there's a case in the 60s called Mapp v. Ohio, which involved possession, a seizure of pornography in a person's house, a dollary map. And that could either be, a First Amendment case or a Fourth Amendment case. Did they have a lawful permission to search, or can they criminalize pornography? So a lot of these cases could either go either way, right? For example, Bowers v. Hardwick, this was the case I mentioned earlier. I think they were in the guy's house because he had some outstanding warrants, and then his roommate allowed them into the house, right? So the roommate let the cops into the house. So did the roommate have permission to let them enter the house? That's a never-ending Fourth Amendment question. So almost all these, but this just proves a point, right? It's impossible to enforce a sodomy ban. I mean, unless you're doing it in public, in which case you generally can't have sex in public no matter what kind of sex you're having. But you can't enforce laws that are applicable to the bedroom, right? How is Connecticut going to enforce a law that banned contraceptive in the bedroom? They weren't. It's impossible, right? You're not going to send cops into a person's bedroom to check under their nightstand, right, to see what they're using. It's ridiculous. So this was one of these bizarre cases where you happen to have cops enter, probably without cause, at the exact moment that two men are engaging in some sort of intimacy. It's like a 1,000,000 to 1 shot. So Tori asks, is this a test case? It became one, but didn't begin as one, right? A test case would have been two men call the cops, say, "Hi, we're having sex, please come over and arrest us." Right? That would have been a test case. It's just ridiculous. But, think of the Griswold case. They said, "Hi, we're about to dispense contraception, please come arrest us." Right? That was Griswold. Or if you remember in Loving versus Virginia, "Hi, we're an interracial couple, please come arrest us." Remember, that was what the lawyer's suggestion was to do. Right? That would have been a test case, which is not a good idea. All right. Questions so far? Okay, so thanks for that question, Tori, and a few other people who chimed in. So we have this case, right? And the court has to decide whether Texas's ban on sodomy is unconstitutional. And by the way, sodomy refers to basically non-vaginal sex. I have to define this because people don't know what it means. It's basically everything, right? Any sort of sexual relations that's procreative, that won't lead to procreation. So don't use your imagination. But you can, I'll get myself in trouble. You're going to cancel me soon, in the last day of class. But you can think what the other things are. All right, so let's just start with, God, I don't even know where the hell I am. I haven't checked the attendance roster, so I'm going to start this policy next semester. I'm sorry. Who's next? Oh, Shawnee. Oh, that's right. You were patiently waiting for like an hour yesterday. Thank you so. I'm sorry. I'm sorry. You were patiently waiting. Okay. So help me out here. Let's just think back to Casey, right? The abortion case. How did the court, or how did the joint opinion go about defining the right in Casey, this right to abortion? How did they describe it? How did they conceive of this right?
What do you mean, how do they conceive this right?
Conceive is a terrible word for an abortion case. Okay, good point taken. What was the nature of the right in Casey? Maybe that's a better way of phrasing it.
I mean, they called it fundamental.
Did they?
Well,
Roe did.
Roe called it fundamental.
I'm asking about Casey. The Casey.
No, non-fundamental right.
But let me ask the question differently. Maybe I'm not getting across. In what way did the court discuss rights? Why did they think this right was so important? Maybe that's the way of asking the question.
I didn't think because there was a legitimate state interest.
No, you're giving the interest, but just why?
I guess that's what you're asking me exactly.
I know. I'm trying to ask you very deliberate, like giving away the answer. Why did the court think abortion was an important right for women to have?
I mean, why do they think it's important for the woman to choose it? I mean, it's her life and her choice. I'm just confused on what you're trying to ask.
I know you are. I'm not going to give it to you. I'm going to try and get you there eventually.
Okay.
But why is that choice important, right? Just why is that choice important to women?
I mean, it's her life and her child. It's her body.
But what? Right, but you're giving me correct states. But what does having that choice allow women to do?
Have or not have a child?
Beyond that, what does the decision to have or not have a child allow a woman to do, according to the court?
I don't know. I mean, that's literally what I can think of.
All right. Troy, are you here? I'm sorry, wrong class. Hisela, are you here?
I'm here.
All right, so let me try the same question. What does having this choice to terminate or not terminate pregnancy allow a woman to do, according to the plurality, the joint opinion?
I think it was like a fundamental right of privacy that they were able, like their body was like they were entitled to do like kind of like what they want with their body without the government telling them how to.
Okay. So now we're getting closer. Okay, so they're able to define whether they're able to choose whether to have a pregnancy or to not have their pregnancy, and that choice allows women to do blank, fill in the blank.
To have an abortion.
No, I know, but I said they can either have an abortion or not have an abortion, and that choice allows them to do blank. Fill in the blank.
That choice allows them to
What does that choice allow women to do?
It allows them to choose whether.
No, but you're circular. I mean, this isn't convalescence. Often you're just circling, right? You're telling me a choice allows you to choose, but what does that choice allow you to do? Allow women to do? You're going to hit yourself once I say the answer in a minute. Not done yet. We'll try one more after this.
They can make.
Please don't put answers in the chat. It's never a good idea. It's really annoying. Actually, people do that. I'm trying to do something very deliberate.
They're trying to. That they have like they can choose to.
So let me ask this question differently, right? What if the court came out the other way in Casey and said that we're overruling Roe? Okay, for sure that would have allowed states to limit abortion, but how would women have reacted to that decision? How would that have affected how women go about?
Would it be about family planning? Like they were able to like plan.
Okay, we're getting closer. What does Roe allow people to do that they may not otherwise be able to do?
So they can like plan for like if they wanted to get an abortion and not have kids.
Not just about abortion. Go beyond abortion. Go beyond abortion. This is not just about abortion. What does Casey and Roe allow to happen that may not otherwise happen? Stop and put abortion. It's not just about abortion.
So I guess like something like marriage, and so I mean I know that marriage was like if you could like it was like really frowned upon historically to like have kids out of wedlock. So I guess that would allow them to like not have kids out of wedlock, abortion. I don't know.
All right, we're getting closer. Rachel, I think you're here. Rachel.
Yes, I am here.
Okay, Rachel. Let's try this a different way, right? What is liberty? According to the Casey plurality, what is liberty?
That would be, I think, just to maintain like a right that's not burdened by government intrusion.
And what does liberty allow people to do?
I would say make choices.
And why do people have the right to make choices?
I think it's kind of touched in the cases today where your own personal morals, like you can develop those without intrusion.
Oh, now we're getting closer. How did Justice Kennedy, remember I made fun of his very high-minded philosophical language. How did he define liberty in Casey? What was liberty about? It was not about abortion. And this is why I was so hard on Shawnee Hisela, because they talk about it was not about abortion. It was, and that's how you understand Lawrence. It's not about sodomy. What was the liberty discussed?
Like a personal liberty, or I know today, like it's the dignity is like what we're discussing.
Closer. But why are these things important? What do these things allow you to do? What does the ability to have relations with whom you want allow you to do? What does the ability to have an abortion if you want allow you to do? What are these rights about?
I think it's about, I don't know, like you're asking about liberty, but that's what I think the answer, like that was what I was planning on telling you. Like this allows you to maintain your liberty, and I think
just don't use the word liberty. Use a synonym. Just you're so close. Just use another word for liberty. It allows you to maintain your own
morals.
Who's defining those morals?
I think that would be a personal.
Yes. So you get to define your own
personal.
Good.
Morals. I don't.
Okay, you're so close.
Personal actions.
Okay, you got it. Okay, very good. Moses, I saw your hand was up, then went down. Is there something you want to add? I saw your hand was up a minute ago.
I was going to offer page 1210 in your book.
Hold on. Let me pull it up. I don't know if it's on page 1210. Let me just pull it up.
Well, it's the answer to your question that you've been asking. That's what I was going to offer.
Okay, what's on page 1210? Where are we looking?
The heart of liberty is the right to define one's own concept of existence.
Perfect. That was the exact quote I had in mind. If I had a sentence, that was the exact sentence. Just read it one more time, please, Moses. Perfect answer.
So, top of 1210, at the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life.
That's it.
Beliefs about these matters could not define the attributes of personhood were they formed under the compulsion of the state.
Perfect. Exactly what I was getting. I think Rachel, by talking about morality, was more or less getting at that. But this is the word I was looking for. Okay, very good. Thank you so much, Moses. Excellent. Justice Kennedy, again, I make fun of his sort of lofty language, but he is getting at a specific point here. And I think Moses and Rachel and the others were sort of getting to it. Liberty is not about getting an abortion, to Kennedy. Right? Liberty is not about getting or having same-sex relations, right? And Justice Kennedy says we cannot define liberty so narrowly, right? It's a mistake. If you define liberty as the right to get an abortion, of course there's no right to abortion in the Constitution. Of course, it's ridiculous, right? If you define liberty as a right to have, gay sex, of course it's not in the Constitution. That's insane. But if you define liberty as the right to make choices, intimate and personal choices, right? To define your own concept of existence, right? You get to define who you are. That is a different conception of liberty. Now, does the 14th Amendment let you define who you are? I have no idea, right? I mean, he's just sort of making it up as he goes along. But if you accept the Kennedy understanding of liberty, then Casey and Lawrence make a lot more sense, right? Just with Justice Kennedy, there was something there. He had this sort of libertarian impulse that you have the right to define who you are. And that was a starting point for all of his cases. And if a state tried to interfere with the ability to define your own existence, then they were acting unconstitutionally. Now, again, I have no idea where he gets that from. He sort of made that up, right? That was his philosophy, and he read into the 14th Amendment like Herbert Spencer, right? He did his own Lochner thing, which is a different story. I don't care about that. I don't care why Anthony Kennedy did what he did. That I'm long past that. I want you to understand the basis of Casey was the basis of Lawrence. It was not about some sort of right to privacy, or even a right to abortion, or even a right to choose to have an abortion, right? That's why I think Shawnee was talking about choice, or maybe it was Estella as well. It's not just about the choice of having an abortion. It's about the choice you make central to your dignity and autonomy, right? To define who you are. And he writes, and this is page 1210, Moses read a minute ago, beliefs about these matters cannot be defined by the state. The state cannot compel people to adopt these beliefs. They're the beliefs that individuals must hold on their own. They choose their own morality, right? People define their own liberty. You choose your own adventure, so to speak, right? Some people want to do X, some people want to do Y, some people want to do Z, and people can choose their own lives. They want to live with a man, they want to live with a woman, they want to have an abortion, they don't want to have an abortion, whatever it happens to be. That is for people to decide, right? That's the basis for Justice Kennedy's entire jurisprudence in a nutshell. And I was deliberately not giving it away to Shawnee and Estella because I wanted to sort of just scratch and claw to the right answer. Eventually we got there. But these are really, this is the core of Justice Kennedy. That one paragraph is everything to Kennedy. You have the right to your own autonomy to define who you are, and the state cannot impose that upon you. Right? It's not just about who you're having sex with or who you're having a medical procedure with. That's silly. And indeed, Justice Kennedy says if you define liberty so narrowly, then of course you can ban sodomy, right? But that's not what liberty is. Okay. Yeah, but you're all on the right track. Just I wanted you to take a very specific path there because the mind of Justice Kennedy is not a straight line. It's just sort of this stew where he just throws different things and mixes it around and you pull out a right. It's not like here we have a fundamental right and we apply strict scrutiny. It's never that neat with Justice Kennedy. It's always a sort of dance, this game of how to get to the answer. And you have to read these long opinions, but there's a there. He does have a philosophy. And he does consistently use that philosophy. He explains it in a way that reads like a freshman, philosophy paper. Okay. Questions on that? Yeah, Colin, go ahead.
So, with this whole concept of bodily autonomy and I guess moral autonomy, how do you reconcile this with Buck v. Bell?
What a good question. Excellent question. Look, one of the great tensions in Roe is that Roe favorably cites Buck. Right? We talked about this, a week or two ago. And people who like abortion rights don't like acknowledging that point. They just sort of pretend it didn't happen. But they have to. And the reason why is you think about abortion laws, right? If a state, let's just say a state bans abortion in the third trimester, which Roe said you can. What does that mean to a woman? It means she's required to carry a child to term for 3 months that she doesn't want. And after the child's born, she is the custodian of that child. And I'm sure as you know, when you're the mother or the father of a child, the state imposes a lot of responsibilities. You can't just starve the child to death, right? You can't just throw the child in a dumpster, right? You can give it for adoption, but you can't just abandon it. I think now states have laws that you can basically drop a kid off at a fire station. So I think these are fairly novel things. I don't think were always around. But for much of history, if the state forced you to have a child and carried to term, then you had to raise that child for a lifetime. And if you gave that child away, you had to suffer the pain of knowing that you gave your child away for adoption. That's not an easy thing for a lot of people. That's very hard. That's a huge burden to impose on a person. And whatever views an abortion, just recognize that there are costs when you ban an abortion, right? That you're imposing a condition that goes far beyond the pregnancy, right? After 9 months, there's a little kid running around or crawling, and then they run, and they don't stop running. In order for Justice Blackmun to make that point, he needed to reach for one of the most egregious precedents, which is Buck, right? Which says the state does have an interest over your body. Now you're asking me, how would Justice Kennedy reconcile, his view with Buck v. Bell? He never tries. This is perhaps my single biggest complaint of Justice Kennedy. Not his language, whatever. I can read through it. He never addresses contrary arguments. He speaks as if he's from Sinai with the tablets, right? Just that this is the gospel. And Moses is laughing. He speaks as if he has, complete moral authority to say what he needs to say, and he never responds to dissents. He just doesn't do it. Go read all of his committees, Lawrence, Obergefell, Windsor. He never responds to Scalia, just as if he doesn't exist. It's just, I have 5 votes. I am, the Almighty. I am Zod. I can do whatever I want. It's a Superman reference, right? And so, Colin, I don't know your answer. I think in order to have, Roe, you need Buck, right? Because if you get rid of Buck, then that means that they couldn't ban abortions in the 3rd trimester, I think. Right? I think that's what it would mean. And maybe some people would like that result of a pure libertarian paradise where there's no restrictions on anything and everyone's just unto themselves. Which is why I think Buck is a hard case, right? I know we can say it's an awful decision. Justice Holmes wrote it in just this really callous, mean-spirited fashion. But what would the opposite holding mean? If you say the state can't sterilize people for a serious interest, what about vaccinations, right? What about mandating people to get the COVID vaccine? Something I'm thinking about now, right? So I think I had this exam question one year where I asked someone to write a dissent in Buck v. Bell. That was basically the exam question. And that was not an easy question, right? It's actually a lot harder than you think to write a dissent in Buck v. Bell. I mean, of course, say this is awful, Carrie Buck was screwed, but let's just say she had a fair trial. Let's change the facts so that she actually had a fair trial with a real lawyer and a competent judge, right? All the evidence was presented. There were witnesses, everything that was needed to be presented. And at the end, they said, you are an imbecile. Write a dissent for that the state doesn't have this power. It's harder than you think. So I think Justice Kennedy simply ignored those tensions and just moved forward. He said, well, we're not bound by the past. We're not governed by what was in the past. New generations reveal new insights about the human condition, and we move on. And that was Kennedy. It didn't matter. Nothing mattered, which is why it's, when you have your flow charts, your outlines, you're trying to put a Kennedy opinion, it's like spaghetti just all over the place. You can't flow chart it. But anyway. Yeah, I'm passionate about this. I'm sorry. It's true. Not because I care so much about the substance, but just teaching it is really tough. Because every year I have these students struggle asking the same questions. How do you reconcile Kennedy with this case? In this case, I don't know. It doesn't try. Just it's there. All right. Other questions? All right. Other questions? All right. So I think we're about halfway through Lawrence now, right? This is the most important point. The way that Justice Kennedy defines liberty is not as a discrete right to obtain an abortion. It's not as a discrete right to obtain or to engage in sex with a person of the same sex, whatever, right? Liberty is the right to define your existence, define who you are as a person. And the state must give you the space to do that. And a central element of that definition is the right to choose your reproductive health, right? If you decide that you don't want to have a kid, and that's who you are as a person, you can make that decision. That's Casey, right? If women want to define themselves, to have careers instead of families, they can make that choice. And he had that one line where he said, all these women have relied on this, they formed their careers around it, which seems kind of patriarchy, if I may. But what he's getting at is women can define who they are, and the state can't intervene. Now, it doesn't actually mean that, because of course they can ban abortion after viability, right? So all this crap is just about before viability, right? It's just why he thinks incoherent, right? If he actually meant what he said, then you wouldn't have the viability line. If he actually meant what he said, then you would have it at all 9 months, right? It's like women have this right to define themselves until viability, right? Because at that point, there's some other interest that's more important. Well, so that's who? Isn't that morality, right? Aren't you making a moral decision, right? Once you give in the line at viability, I think Casey implodes. If you actually define it, Roe at least had the cohesiveness to say that we're basing this on a fixed trimester framework, and we understand there are different points, different balances. But Kenny's like, you're defining yourself. If that's the interest, that's a lot broader than the right that Justice Blackmun wrote about. It wasn't for Justice Blackmun. There's a right to choose to have an abortion, and the right goes away when the baby's too big. Right? I can explain that to you in a nutshell. But if this is liberty, the right to define yourself, that liberty extends beyond when the baby's too big. You're defining who you are. So there's a tension. A similar tension, I guess, if I can make a segue in Lawrence, if you can define yourself by having a relationship with a person of the same sex, why can't you define yourself with two people of the same sex, with bigamy, right? Or why can't you define yourself by having sex with your adult consenting sibling? This is Scalia's point, by the way, which is mostly understood. People think, oh my God, Scalia's comparing sodomy to bestiality. That wasn't his point. Scalia's point was different. He was saying, if you have the right to define your existence, and Kennedy means that, then why can't you define your existence by having two partners? Bigamy. Or why can't you define your existence by having a partner who is your consenting sibling? Again, if it's minors, it's a different story, because it's not, you can't consent. But if you have a consenting brother, two brothers who are over the age of 18, they can't reproduce, they're not creating offspring with birth defects, why can't they define that happiness? I had an exam question a couple of years ago, this was effed up, where you had two guys who were dating, and they were about to get married, and they randomly took a DNA test, the 23andMe, and it turns out they were brothers. And they were in love, and they wanted to get married, or maybe they already gotten married. I can't remember which one it was. I'm forgetting, but they were, Bert and Ernie, that was it. Yeah, I called them Bert and Ernie. Sorry, it's too much Sesame Street. Why can't you define your existence with regard? If you notice, Kennedy doesn't mention incest or bigamy in his Obergefell decision. He sort of just says, well, that's not an issue. Of course it was. In fact, during the Obergefell arguments, I think Alito or Roberts asked about bigamy, and the lawyer had no answer. She was like, blah, 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 blah. She ran off. She didn't even answer because she didn't have one, right? So, why do you draw the line at viability if it's liberty is defining yourself? Why do you draw the line at one male partner but not two male partners if liberty is about defining yourself, right? Who's to say what love is? One more anecdote. One of the most unintentionally popular blog posts ever wrote. I wrote a blog post years ago called "Why Can the State Ban Two Brothers from Having Sex?" Just the people who found this, I don't even want to. But my point was, okay, so maybe you say the state can ban a brother and sister from having sex because it prevents the spread of congenital defects. Although, to be frank, people can get married who have markers for Tay-Sachs and otherwise. We don't stop them from getting married. So I don't think that really works. But two brothers, they can't reproduce, not without intervention of science at least, right? Why can't we say Bert and Ernie in my exam question are unable to have a relationship? Right, so the Kennedy philosophy of defining your existence might sound great, but it collapses really quick. It collapses real quick once you go beyond the case at hand. there have been actually challenges to bigamy statutes in the wake of Obergefell, and the courts are like, we don't want to do bigamy is when you have multiple spouses or multiple partners, like 2 or 3, right? A Hugh Hefner style, right? The court's like, we don't want to do this. We don't want to talk about bigamy. We just don't want to talk. Leave us alone. We have gay marriage. Cassidy asked in my exam, yeah, they wanted to have sex on YouTube. That was also part of it. That was a First Amendment issue. That's a different issue. I think they, can the state criminalize a brother and brother from having sexual relations? This is not where I wanted the class to go, but I guess it's there. This is not a goal I wanted the class to go, but here we are. It's the last day, whatever. I had my torts professor my 1L year. He was not very good. But on the last day of class, he was like, all right, let's learn some mother effing torts. Like he just went at it. So this is sort of like you throw down. Yeah. The A+ answer, the first word was just awkward. That was right. And by the way, I've not written your exam yet, so I have no idea. I will not write it till after the review session. That's my general policy. That way I don't give it away inadvertently. So I have no idea what your exam question is. All right. How do we move on from here? All right. All right, so let me try to summarize a bit and get us back maybe even slightly on track, if I can. The Kennedy opinion defines liberty at a very broad level. It's not about just a particular sexual act. It's about what he says the most private human conduct in the most private place is home. It's a personal relationship, right? It's within the liberty of the person to choose who they're having sex with, right? It's not just about having sex. It's about defining yourself by choosing to have that type of sex. I mean, it's a very bizarre way of thinking about relationships, but that's how Kennedy approached the world. Okay? Next, Kennedy acknowledges that there's been a long history of statutes that ban immoral sex, for example, sodomy. But he says that's not enough. And here he relies on Casey with one of the most important sentences in Casey. He says, our obligation is to define the liberty of all, not to mandate our own moral code. Whatever that means, I don't know, but he's saying we can't impose morality on everyone. He doesn't actually mean that, because you can prohibit incest and bigamy, but like he talks the talk but doesn't walk the walk, right? He lays out this very broad philosophy about liberty, which if actually taken seriously would be like a libertarian, word in Galt's Gulch, right? Which is a libertarian fantasy. But he doesn't actually do it. He sort of just cuts it off. You have all this right to define yourself, but once it is viable, they can ban abortion, right? You have this old liberty to define yourself, but make sure it's not your brother, or make sure it's not 3 people. It's just sort of, I don't know, this tension that I always see. Then Kennedy says the state cannot demean the existence of gay people. What does it mean to demean? He doesn't really ever explain what demean means and dignity means. These are phrases he uses, doesn't really define. He says that the state can't control their destiny by making private sexual conduct a crime. What's mean controlling their destiny? Imagine if a state says you can't be in a relationship with Lawrence and Garner, then that's controlling who they are and how they can define themselves. Okay. He quotes Casey again. He says, it is a promise of the Constitution that there's a realm of personal liberty which a government may not enter. All right, so again, Casey is the basis for Lawrence. One follows from the other very clearly. Okay. And in the end, we get to the conclusion that the Texas sodomy statute is unconstitutional. Why? Do we have a suspect classification that's reviewed with strict scrutiny? No. Do we have a fundamental right that's reviewed with strict scrutiny? No. the actual basis of Lawrence is not entirely clear. I mean, again, we read all the stuff about liberty and dignity and defining yourself, but why is this statute unconstitutional? Now, let me give you some sort of inside baseball. If the court had said that classifications on the basis of sexual orientation are suspect, that would have meant gay marriage bans were unconstitutional. Right? If the court had actually said that you have to treat sexual orientation like race, then under Loving, you can't have bans on gay marriage. That would have been immediate. And in 2003, that was a bridge too far. Even Kennedy wasn't that insane. He knew that wasn't going to work. They were probably a constitutional amendment to override that decision. I think it would have passed in 2003. Did the court say there was a fundamental right to engage in sexual relations? No. Right? So what we have here is effectively a rational basis opinion. Right? Most, I'm not sure to answer your question. What do you mean criminal penalties? What do you mean? For what?
Well, you're talking about the fact that Kennedy doesn't define this stuff, but he goes into this very, if the state is going to criminalize same-sex sex, you now get a criminal record. And so, and he lists that out. You get a criminal record, now you have to report it to on job application. Now, if I get a criminal record right now, I got to report to the state bar. And so now someone else or the state is beginning to impact my future or my destiny in a way that I couldn't have imagined before. So Kennedy does do some of that. It's not without.
Right. The consequence of being arrested, you have to report it. I think that's for any crime. Any crime you have to report it. I think the threshold question is, can they criminalize it in the first place? In other words, once you have a crime and you're convicted of it, there are consequences. I think everyone agrees with that. But can you criminalize this in the first place such that you can later impose these collateral consequences?
And that's what Kennedy's ultimately questioning. But that's key to that. I would say that's key to this case as well, is the consequences that follow if it was criminalized or because of criminalization.
Right. I mean, let's say you had sex with a prostitute. Just a different, not you, but someone had sex with a prostitute. I would say you, and I realize I shouldn't. But let's say John Doe, he's a John, has sex with a prostitute, right? And he's arrested. He's caught in a sting operation. He would then have to report that to his employer at the bar. Why is prostitution a crime? But let's just move away from sodomy for a minute, right? Why does a state have the power to say that people can't have sex for money? Lots of states have promoted legalization. Lots of countries in Europe and elsewhere have created it's a regulated industry. You're unionized sex worker. I mean, it's an entire field of labor. Is it the oldest profession or is lawyering the oldest profession, or which one's first? Right, but it's one of the oldest professions. It's about morality, right? It's about saying that people should not be having sex for money. I mean, you could, pay a person for some other service and get the sex for free. It's like with the bakery, you buy the bread and you get the milk for free. But Leo Nebbia, but just change sodomy to prostitution, right? Why does they have the power to ban prostitution? You'd have to report that to your boss and to your bar and everything else. Or even consensual use of narcotics, right? I mean, if you're home you're smoking a plant that you grew in your backyard, like Angel Rach, right? Why is the state banning you smoking a plant? I mean, people put lots of things in their body, I mean, I don't want to make this point too grossly, but marijuana and sex have something in common. You're putting something in your body, right? There's body stuff going. I could cancel last class, but it's a very similar. Just autonomy means what are you doing with your body, right? Are you putting a plant in there? Or are you putting? I'm going to stop, right? But you're doing stuff to your body. That's what these cases are about. Right? Are you removing something from your body? Is there a fetus in there? Right? What are you doing to your body? And that's what all these cases concern at the most basic level. I say this for the last day of class deliberately. It just has to come at the end. I suppose I did at the beginning, but we start with boring stuff about banks and ferry boats. We end up with this stuff. Yeah, body stuff. I stopped myself mid sentence with that one. All right. I think I'm done with Kennedy's majority opinion. I think we've beaten it to the ground. Anything else you want to talk about? I do want to talk about the other opinions. I could teach an entire semester on Casey and Lawrence and Obergefell, an entire semester. There's just so much in there. I actually used to assign, when Obergefell first came out, I would assign the entire opinion. It was 100 pages long. I did an entire class on just that. My students hated me. Over time, I sort of moved. It's not quite as important, but I used to teach it very carefully. All right, let's talk about. Leni, go ahead.
So I hope I don't blow this after you've spent so much time on it, but
it's okay.
This was not an equal protection case because the law applied equally.
Well, hold on. Was all types of sodomy prohibited here?
I think so.
What did Justice O'Connor say? I was actually about to get to O'Connor in a minute, but this is a good segue. What did O'Connor say in her concurrence in Lawrence?
Oh my gosh, yes, there it is. She didn't join in overruling Bowers, but this holding is based on 14th Amendment equal protection.
Well, but why? Why did O'Connor think it was a violation of equal protection?
So what I wrote down is it's unconstitutional because the law applies to same-sex but not to different-sex couples.
So if a husband and wife engage in anal sex, was it a crime? Question.
Well, no, but then we're going into the marital bedroom, so...
Forget marriage. If a man and a woman engage in anal sex, was that a crime in Texas?
I don't think so.
But if two men engaged in the same act, was it a crime?
Yes, that was.
Okay, right.
That was this case.
So why did O'Connor think that this law violated the Equal Protection Clause?
Because it was only applying to the same sex.
It was a sex classification, right? Right. Mm-hmm. Thank you, Leni. Right? It was a sex classification, and we have intermediate scrutiny for that, right? With Frontiero and Virginia.
So before we got to the Justice O'Connor concurrence, what I was going to ask about was a case Romer,
right?
And that invalidated a state amendment. It deprived them of equal protection. It was born of animosity towards homosexuals, and there was no rational relation to a legitimate government purpose. So that all lines up, right? There's no disconnect there.
All right, let me try and simplify this for you a little bit, okay? This is for everyone, not just for Leni. Bowers v. Hardwick was a case we discussed a little bit earlier. In Bowers, Georgia banned sodomy both for men and women alike. No one could do it. Okay. O'Connor upheld that ban in 1986 or so. But the statute in Texas said only same-sex sodomy was banned. So a man and a woman could do it, but two men could not do it. All right. O'Connor said that's a sex-based classification. That's unconstitutional. Right? Why didn't Justice Kennedy choose that route? Right? Why didn't Justice Kennedy make the O'Connor opinion the majority? Instead of all this philosophical waxing about dignity and defining our autonomy, he said this is a sex-based classification. Well, maybe one response is, well, Texas could have enacted the Georgia law to ban sodomy for everyone. Would Texas have done that? Maybe not. Probably not. So they could have just ended this case altogether by says, you know what? This is sex-based discrimination. Go away. But that would not have been palatable. Because once you say sex-based classifications are like sexual orientation classifications, the marriage law has become very tenuous, right? It's hard to justify a ban on gay marriage if you treat sex and sexual orientation in the same fashion. Justice O'Connor, in her opinion, says, this doesn't affect the formal recognition of marriage. And Scalia's like, give me a freaking break, right? Come on. We're not stupid here, right? Once you say that you're opposing intermediate scrutiny for sexual orientation, gay marriage is hard to defend, right? Once you say that morality is not a legitimate basis on which to separate gays from homosexuals and heterosexuals, once you make that judgment call, it's hard to defend the marriage law, right? That's why once you get to Obergefell later in the 2015 or so, it was a foregone conclusion, right? Lawrence kicked out the foundation for morals-based legislation, right? Lawrence said it's not the government's job to define morality. We do. Pretty much, right? In other words, people do. People define their own morality. It's not for the government. And once you say there's no moral basis to disapprove homosexuality, right? You can't disapprove of gay relations. Once you kick that justification out, then there's no good reason to exclude gays from marriage, right? That's the basis, right? There are other reasons. You want to move incrementally. You want to move slowly. Fine, right? But if the state cannot rely on notions of morality to impose legislation, then it becomes really tough to defend a marriage law, which is why Obergefell is the most foregone conclusion ever. There was no dispute how that was going to end. It was just like this, It's like when you have a book and you flip to the last page and you spoil the ending. Harry Potter dies, whatever, right? You knew the ending of this one. There was no doubt in anyone's mind. Oops, sorry, something just fell. All right. Oh, Harry Potter. Does he die? I don't even know. I never read any of the books. But, you know what I'm saying. Rosebud. All right. Questions? All right. The Scalia dissent in Lawrence was pissed. He was pissed off. I mean, you've seen some angry Scalia. I think this was his, not his angriest dissent, but it's definitely top three. It's up there. And the reason why Scalia is so angry is he knows where this train is headed, right? He knows this is going to wind up with gay marriage being legalized. He knows. Everyone knows. It's like the worst kept secret in the world. And he says this over and over again. Look, if you take this position seriously, morals-based legislation is done, right? And he means this. I think he's 100% correct on this front, right? You cannot defend morality-based legislation once you have the Kennedy opinion that you define your own existence. Scalia writes, Lawrence effectively decreed the end of all morals legislation. He's right. He did. And that's it. Kennedy doesn't respond. He never responds. It's I think, at some point in your careers, you're going to have, briefs you're going to have to write. And you might write the opening brief, and then your opposing counsel writes a response. Okay? And then you get a reply. If there are arguments in the response brief that you just ignore in your reply, then that probably means you don't have a good response to it. Right? If your opponent brings up some position that says, look, there's a flaw in your argument, and you just don't respond to it, I think the court will simply assume that you don't have a response, and he wins. You got to come up with something. But Kennedy never feels compelled to respond to arguments that go against the position. He doesn't. He's like, look, I have the votes. That's of all the things I criticize him for, it's the worst. Roberts, again, at least does respond to arguments in dissent. He might do so a little bit, casually and maybe not with the best, but he does engage. He doesn't like to just stand down and just admit he's got nothing. All right. Questions on Lawrence? Questions on Lawrence? No? Nothing? Okay. All right, let's talk about what happened after Lawrence. In the wake of Lawrence, many states enacted bans in their state constitution that limited marriage to a man and a woman. This was a huge issue. In fact, the Republicans in 2004 won. George Bush's reelection was boosted significantly because there were state ballot initiatives to ban gay marriage. This was a huge turnout method. Things like, how can this be? George Bush looks so nice by comparison, but this was a huge issue in the 2000s, right? This was a huge issue. And you also had this federal law, DOMA, the Defense of Marriage Act. DOMA did a lot of things, which I don't have time to discuss all of them, but there was one aspect that was significant for our purposes. For federal law, it defined marriage as a man and a woman. So if you want to get, let's say a joint tax return, right? You could not file jointly as a married couple if you were same sex. Even if your state authorized gay marriage or a civil partnership, right? It provided a single definition nationwide for federal law. Well, you have Edie Windsor. She was with another woman, Thea Spire, they were together for decades. Very sweet story. If you were just Google Edie Windsor, she was a really good story. Thea Spire died, and Edie Windsor inherited a lot of money from Spire. If a husband were to inherit an amount for a wife, there's a deduction where the inheritance tax is modified, and the specifics are not important. But Windsor had to pay more in taxes from the inheritance because it was a woman than she would if it was a man. Even though I think they had been married in Toronto, if memory serves. They were in Canada somewhere. All right. So we have this challenge to DOMA. And Windsor was a strange case because the Obama administration did not defend DOMA. They said, we think it's unconstitutional. Exactly why they made that decision was political. Lots of books written about it, but that's not important here. The court, by a 5-4 majority, said that Section 3 of DOMA was unconstitutional. And I think once you have Lawrence, Windsor was inescapable, right? If the government cannot rely on morality to justify this definition of marriage, what interest can they rely upon? Well, I think there's some justification that you want to have, a single definition nationwide of marriage. It creates easier administration, less paperwork. And the court says, no, that's not enough, right? The court says that's not why this law was enacted. This law was enacted because people had hostility towards gay people, right? Members of Congress were hostile to gays and lesbians. And that is not a legitimate state interest, right? Once you say that moral disapproval of sexual relations is not a legitimate interest, right? You say you cannot base legislation on moral disapproval, then DOMA becomes very hard to defend. Very hard to defend, right? That's why the Lawrence move of kicking morality out of state making was probably the most important thing Justice Kennedy ever did in his life. We won't remember any of his reasoning, right, or his actual philosophy, but that single move to say that moral disapproval is not a valid basis for legislation was earth-shattering, right? That's why it created such a huge backlash. And that's why Scalia was so pissed. He saw exactly where this was going, right? He knew. All right. Again, I didn't give you the full Windsor opinion to read. Randy wants to take it out of the case book. I think it's important just for a little bit, but it'll probably stay in. We have these long discussions of what cases to add and what cases to subtract. It's a very long process, but I think we're going to keep this in just at least maybe another edition. We'll see what happens with some of the gay rights cases in the next few years. Okay. Questions on Windsor? Anything on Windsor? All right, let's move on. Oh, Alejandro, I don't have time to do Glucksberg. I'm sorry. We're just gonna. I can't do it to this class. But it's a good question. But just I'm not gonna do it. We don't have enough time. I had to remove a lot of stuff this semester, and that's one thing I'm just gonna remove. We come now to Obergefell, which is in 2015. Not 5 years ago. You all remember it if you were in college, or if not, maybe you were in high school. I'm not sure how old you all are, but at least you have some living memory of this case. Jim Obergefell actually came to Houston a couple months after the case was decided. I think it was at Discovery Green, so I think I walked over from school. Back then, we were allowed to actually be in person. I would walk from the school to Discovery Green and actually see human beings in real life. That seems so quaint by today's standards, right? We were all sitting there in chairs next to each other, watching a speaker. Imagine that. We're going to tell kids one day when we were kids, we were allowed to see each other in person. We weren't just all in these little stupid squares for our entire lives. And before the event, I sort of, I walked over to the stage and I sort of just started talking to Obergefell. He's a really nice guy. I had my pocket constitution, and I asked him, would you sign it? Because I have a collection of signed constitutions. If you ever come to my office, I'll show it to you. Very nice. All these judges signed constitutions. And then I just thought, I was like, So then I flipped to the 14th Amendment and I said, here, sign this. And I wasn't really thinking about it. And then he signed, on the same page as the 14th Amendment. So you have Section 5, and he signed his name under Section 5. And I think he wrote Love Won or Love Prevailed or something like that. It's at school. I'll find it later. Maybe I should go back. And then he wrote Jim Obergefell. And I think, it was such like a poetic thing that he basically wrote his name into the 14th Amendment. That he basically amended it. He put Love Wins or Love Prevails in the 14th Amendment. And that's how I view the Obergefell decision, right? They basically incorporated this standard of love and intimacy into the 14th Amendment. And it was like this Zen moment. It's like, wow, thank you. You gave me this really good, this really good philosophy, this really good teaching moment I can use for my students. And I usually bring it to class, but unfortunately it's stuck at school. So I can't do that. But it was a good moment for me to just to kind of see that in person. And he's a really nice guy, by the way. And as it turns out, Obergefell and Hodges, they became good friends. Who the hell is Hodges? He was he had some position in the Ohio government. I can't remember what it was. It's not very important, but they've actually become friends. And they actually wrote an op-ed jointly opposing, I think, President Trump on something. So, what difference does it make? But they became friends. So even on the opposite side of the case, they become close later on. All right. So now let's try and do doctrine. I have 20 minutes left. Obergefell Lawrence and Windsor were very vague on their rationales. Was it due process, right? Was it equal protection? Obergefell is more conscious about the doctrine. It relies on due process, and it relies on equal protection in a very deliberate way. But it still does not say that sexual orientation is a suspect class. It does not say that. It does say, though, that homosexual relations are fundamental rights. But it's a weird fit in this case because we're not dealing with a prohibition on sex. We're dealing with a prohibition on marriage, right? In other words, the right at issue in Lawrence was about the right of intimacy in your bedroom. But this case was not about intimacy in your bedroom. It was about seeking approval from the state. You're seeking a license, a marriage license from the government. So the actual right at issue was not engaging in sex. The right was different. The right that was fundamental was the right to obtain this recognition from the state. All right. All right. Who's next? I completely forgot where I was. Someone's been waiting for an hour, just like dreading me from calling out her or him. Who's next?
It's me.
It's you, Alyssa. Thank you, Alyssa.
Yes. Hey.
Hi.
Yeah.
Hey, how are you? Alyssa, let me ask you a question, please.
Okay.
Why did Ohio, why did other states limit marriage to a man and a woman? Why were these laws enacted? I feel like I asked. I think it was Rachel yesterday about why were these abortion laws enacted. I can't. That's someone yesterday. Why were these bans on marriage enacted, or same-sex marriage enacted?
I think that the courts kind of thought that they were just doing it to hold up like the traditions, like the precedents, I guess, of how it's been, I guess, and they were just trying to keep it the way it was. Yeah,
but so okay, they're trying to preserve tradition. Let me ask you the follow up.
Yeah,
like kids always ask why? Why are they trying to preserve traditions?
Maybe because the majority in that state didn't approve of it.
What's the word that disapproved?
Mm-hmm.
Why? The majority disapprove.
They disapproved because they maybe thought it was like socially not acceptable, or they just didn't agree with it.
Let me ask a more simple question. Historically, why did marriage exist?
To procreate.
I think you're right. What do you mean to procreate?
For a man and woman to have children. For them to, I guess it'd be allowed for them to have children.
Well, okay, so that's true. So being married allows. Being married was the way to have children, but my question is a little bit different. Why did marriage exist in the first place? Why did marriage come into existence in the first place?
What did marriage?
Marriage existed long before Anthony Kennedy came around, right? Why did marriage come into existence in the first place?
To keep people united together and not, running around crazy.
I think you're really close, right? Why was it important to keep people together and not running around like crazy?
And to have some control in.
Control for what? Why was that important to have?
And to have like order, so it's not chaotic.
Chaotic for whom?
In the society.
Chaotic for whom in particular? Why is order and stability important with husband and wife? Why is it important? Who's it important for whom?
For the husband and wife?
No, not just for them. Screw them. They're not that important. It's not. Ain't about love.
For the government?
No, what do husband and wife produce?
Oh, children.
Thank you, my goodness. Thank you.
Oh, yeah.
I every year, Alyssa, you're not alone. Every other sort of like this. Oh my God, no! Of course I'm so. Yes, it's for the children. Thank you, Alyssa. Yes. Right? It's for the kids. It's for the kids, right? Kennedy acknowledges that marriages existed throughout recorded history in every civilization in the world, in every continent, right? Groups that never interacted. How did they all come around to the same idea? It was based on a fairly simple knowledge that if a man and a woman have sex and they have a child from that union, the best way to have that child being raised is with both parents. So society prefers and perhaps pressures those who want to have sex to do so in a union that will lead to stability for the children so the next generation can survive. Right? If people could just, run around? If people could just run around and have sex with whoever they want, then you have lots of single moms who won't be able to take care of their kids. And those kids may not survive. And that's not good for society. That's the historical basis of marriage. And I don't think Justice Kennedy disagrees with that basis. I think he more or less accepts it. What I think Kennedy says is that the marriage laws that came around the 1990s and the early 2000s were not really based on trying to have responsible procreation. They were based on a moral disapproval of gays and lesbians. And Lawrence said that you can't have moral disapproval. You see how important Lawrence is, right? With the Justice Kennedy, he just keeps citing himself. He cites Casey, he cites Lawrence, as if that's gospel, right? I mean, that's just, can you imagine, you go into a legal writing competition, and you just cite yourself as authority? I mean, wouldn't that be cool, right? You make your own precedents. I mean, it's good to be the king. But he keeps citing himself. And when you have the combination of Lawrence, which Thomas cites himself quite a bit, and he cites dissents, in fact, too. When you have the combination of Lawrence, which is you can't consider morality, and Casey, which is define your own existence, right? You have these very broad restrictions on the state's powers. Oh, yeah. Thomas loves his own string cites, which cites like 7 times in a row. See, I've been saying this for 20 years. Listen to me already. Thomas is going to have his moment now. I mean, just want to make this point, because you're talking about Thomas. Usually in the Supreme Court, the justice who's most senior in the majority assigns the majority opinions, right? Usually that's the Chief Justice. But if Roberts is in dissent, that means Thomas can now assign the majority opinions. And I think we're going to see a lot more Justice Thomas. We'll see a lot more majority opinions from Thomas. That's going to happen. Or at least Thomas will give it to his buddies if Roberts is in dissent, which is why I think Roberts will not be in dissent. He doesn't want Thomas running the show. Right? I mean, once Roberts dissents, Thomas is in charge, which is a very different world. So just you can mock the Thomas dissents, but I think they're going to be majorities in due course. People don't realize how influential he is. I think he will be the most underrated justice in the modern era. Breyer close second, but just in the last 30 years, people underestimate Justice Thomas. And, like him or not, he will be extremely influential. Okay. All right. Yeah, the bless his heart is a Texasism. I never know if it's being sarcastic or passive aggressive. I don't know how people are using bless his heart. It's like is it like bless you or F you, right? The world we are. Okay, we have 10 minutes left. I'm going to finish, I promise. Justice Kennedy effectively says, we are not basing our laws on morality, and we define we define liberty broadly. This law cannot stand. Right, so that was the equal protection component, right? That you can't have this sort of morality-based classification. Then we have the due process clause. And here Justice Kennedy channels the Loving decision, right? Loving versus Virginia. And he effectively says that the Loving case was both equal protection and due process, right? Remember, I think I had them separated in your book. I discussed them. And he says much the same here. You can't impose this classification against gays and lesbians. But moreover, you have a fundamental right to obtain the marriage license. Again, you don't have a fundamental right to engage in sexual relations. But you do have a fundamental right to obtain a marriage license. Does that make sense? Right? I would think it's the opposite. I would think that the fundamental right is the right to do something in the privacy of your bedroom. But here, the fundamental right is going to a government building and obtaining a license. Right? It's almost the backwards, the opposite of what you would think it would be. Maybe that's just a product of the fact that Lawrence came first and Obergefell came second. Right? And indeed, just to make this point a little more bluntly, the right to marriage came before federal law prohibited gay discrimination. That only happened a few months ago by Justice Gorsuch. Right? So you had in 2015 that says you can't deny gay couples a marriage license, but the same government agency could fire a person for being gay. Does that make any sense whatsoever, right? The court didn't say the Equal Protection Clause prohibits LGBT discrimination, but you can't deny a marriage license. So in other words, the same government agency would be required to give a gay person a marriage license and can then fire that person for getting the marriage license the very next day. And that would both be consistent with the 14th Amendment. Right? If you talk to a lot of the LGBT advocates, they say they were always shocked. They always thought you would first get equal protection as a suspect class, and then you get marriage later, right? But the court flipped it. They did an exact opposite, sequence they thought it would, which is, it's just amazing. Just if you live through it, how the sequencing happens. All right, just calm down in the chat. We'll maybe take it up after class. All right, questions so far? They say take it outside, but there's no after class. Well, you could have a Zoom off or something. I don't know. All right. Any other questions in the majority in Obergefell? There's so much to discuss, but I wanted to do the dissents for a little bit. All right. It's rare in a 5-4 case for there to be 4 dissents. And they don't all join each other. To this day, I don't know why the dissents broke down the way they did. I thought about it. I don't know, but they didn't join each other. I think they could have. There's a lot of overlap, but they were all very pissed. Roberts doesn't dissent often, but when he does, it's very sharp. When you see who's the real John Roberts, I think it's when he's in dissent. When he's writing by himself, he doesn't feel burdened by the weight of being the chief. I think he just sort of goes YOLO, and he does his own thing. And this, I think, is a close to get to like what pure unadulterated Roberts is. It's a scary thought, but this is where he's at. Roberts is like Lochner, right? Lochner, Marsha, right? Russia, right? Lochner. He says the court is simply invalidating laws because of the court's own sense of morality, right? He analogizes Obergefell to Dred Scott. He said this is another case of substantive due process. Now, he could just as well said Roe, but why do you say Dred Scott? It's a case that everyone thinks is wrong. Like Lochner, it's a case that most people think is wrong. And he's trying to tie Obergefell to these very unpopular, anti-canon decisions. So it's almost like guilt by association, right? If you're using the same methodology as Dred Scott, you have to be an evil decision, which is it's absurd, right? You can have substantive due process without being Dred Scott. I mean, there's like there's a difference between these two cases, right? Pierce v. Society of Sisters and Myrie, Nebraska were due process cases as well. Those are not Dred Scott, but he's very big on this rhetoric, and I think he believes this. He came of age in the era that Lochner was the worst thing in the world. This is how he was raised. If you want to know who John Roberts is, ask yourselves, what did he think in 1982 when he graduated law school? And that's it. He just intellectually he peaked, right? There's no development. Like whatever he thought in the 80s is basically where he is right now. Just anything that happened after the 80s doesn't matter, right? But if it was an issue in the 80s, it's the worst thing in the world. He's just intellectually frozen in amber when he clerked for Justice Rehnquist. That's it. That's why I think he's just. If you want to know what Roberts thinks, what was the Reagan administration's agenda in 1982? That's where he is. Affirmative action, Voting Rights Act, abortion. Yeah. Oh, but what about Obamacare? Oh, that's new. We don't have to worry about that. That's something novel. We have go to the Reagan Library, and that's all you need to know. By the way, the Reagan Library is beautiful. If you ever get the chance to go out to the Orange County, California, stunning place, very pretty. All right, that was Roberts. Scalia again was pissed, but I think by the point of 2015, Scalia had kind of come to acceptance. The stages of law. So you first get was it anger, then denial. I always forget the order, right? You eventually you come to accept it. And I think by 2015 he accepted. He says, "Look, I lost. Right? We had this 15-year game of cat and mouse. I lost." And he wrote that the court ended this debate, and it wasn't ended by legislation or by political debate, but it was ended by 5 lawyers. And I just want to focus on that. This was such a significant attack that Scalia wrote. when he called them 5 lawyers, not 5 judges, 5 lawyers. And he said, my favorite part, these 5 lawyers all from the same 2 law schools. They went to Harvard and Yale. He says they're all from, they're all East Coast lawyers. He said the court doesn't even have a true Westerner. He's like, Sacramento doesn't count, right? Because Kennedy is from Sacramento. California doesn't really count. Only 1 lawyer from the vast in-between. Roberts was from Indiana. And we have Barrett. We have 2 Indiana justices now. They're all from the same circles. And he says, we should not be ruled by 5 lawyers. And he says the biggest freedom is for you to govern yourselves. But I really think Scalia's resigned. He doesn't have the sort of, he's bitter, Giselle. He's bitter. But the bitterness from Lawrence, I think, is just faded. He's like, okay, I got beat. And Scalia died, I think, 6 months after Obergefell. This one was the last major dissents. So this was sort of the end of his career. He wouldn't have. It says 2015, died in February 2016. Yeah, a couple months later. This was one of his last major dissents. Justice Thomas wrote a 3rd dissent. And Thomas made a lot of points, but I want to focus on just one of them. He says it's strange to think of liberty as a government license, that usually liberty is the absence of government. I think someone earlier in class, I can't remember who it was, said that liberty is when the government leaves you alone. I think the first or second person I called on made that point earlier. Liberty is when the government leaves you alone. So how can it be liberty when the government gives you a license, right? That's just a very strange definition of liberty. Now, of course, you have the Loving decision, right? In Loving, they were given a marriage license. Although it wasn't Loving was a weird posture because it came up as a criminal prosecution that they were basically criminal. They were being charged with a crime for getting married somewhere else. I know this doesn't seem like a very good distinction, but the Loving case didn't actually involve the right to get the marriage license. It was about arresting people who got a marriage license elsewhere. I know people don't like that distinction, but Thomas draws it. So I think you have slightly different cases. All right, then you have Justice Alito. He's been in the news recently. He made this exact statement elsewhere. He was talking about religious freedom. And he says that the court is now basically targeted anyone who has views of traditional marriage as a bigot. That if you oppose gay marriage, you are a bigot, and you are no longer able to hold those views. And now these people can only whisper their thoughts in private, but they can't do it in public. And that was the effect of the decision. Okay, that was more rushed than I would like, but I think Lawrence is so much more important. I'd rather spend an hour in Lawrence than the other one. Okay. Questions on Obergefell. If you need to go past 12:10, that's fine. Questions on Obergefell. Nothing? Nothing? Really?
Oh, yeah. This is Moses.
Okay, Moses, go ahead. Aaron next. Yeah, go ahead, Moses.
Oh, sorry. It's just nothing. I just interrupted. Thomas's that line though, from Thomas's dissent, liberty is being understood as freedom from government action, not entitlement to government benefits. I thought was actually a brilliant line, only that it really brought up I thought was the real issue in this particular case, but that was unspoken. Is that it's not that just marriage is about children and that kind of stuff, but the governments give benefits for marriage. Whether it be from tax breaks to property disputes, to wills, trusts, and estates when someone dies. There's a number of benefits that you get from marriage that the government provides, that if you're not in a marriage, you don't get, or you have to hire a bunch of lawyers in order to develop all the documents to get. And so I'm wondering why that wasn't discussed at liberty in this case?
Okay, so I have it's a good question. I think I have two answers. If you need to run, that's fine. You guys can go. It's not required. But I have two answers for Moses. The first one is, what if a state said we're creating something called civil unions, which gives all the benefits of marriage, but it's not called marriage? Or domestic partnerships, or call it something else, right? You get the tax, you get the wills and trusts, you get all the benefits you mentioned. Would that have made Jim Obergefell happy?
It may not have. It would have followed the European model,
right? But
where you have where marriage is simply then reserved for the religious sphere, because that's the other issue that is at play. It's been, marriage is often defined in religious terms or as religious ways, but
so let me try again. One of the issues in Obergefell was children, right? So let's say you're the child of an opposite-sex couple. You say, like, mommy and daddy are married, but then you're the child of a same-sex couple. Oh, mommy and daddy are not married. They only have this second-class domestic partnership, right? I don't think had they focused on the benefits solely, it would have been enough, because the states said, fine, we'll give domestic partnerships, or we'll recognize an out-of-state marriage. I think they had to go for gold here. They had to go for the right to marriage permanent, to eliminate any sort of inequality between these two types of unions, because that's what happened. I think the second answer is the court actually has a line in the opinion. I don't know if it's in your book. I can't remember if it's edited out, where the court says the right to marriage includes also all the constellation of benefits. Right? There's a line. I can't remember if that's in your edited version, but it's a very important line. Constellation of benefits. And what that means is once you have this right to gay marriage, the state can't then separate. It's on page 1279, towards the middle of the page. But it's a paragraph that says, there's no difference between the same and opposite couples, yet by virtue of their exclusion, they're denied the constellation of benefits. Right. That's that line, Moses? So that's where Kennedy, he sort of brings the benefits up on the back end, right? Your question is, why isn't the benefits at the front end? But they're saying, once you have this marriage, you can't be denied this constellation of benefits. So it did come up, but just sort of indirectly to your question.
Okay, thanks.
No, my pleasure. Did that answer your question?
Yes.
Okay, good. All right, Aaron, I think your hand's up.
Yes. I guess just for purposes of the exam, because I'm super confused on what. Me
too.
What basis of scrutiny to apply in these cases.
Yeah, me too. I don't know. I'm not trying to be dismissive of your question. I think you're asking a good question, but Justice Kennedy doesn't really help us. So you're asking about equal protection. He never says strict scrutiny for equal protection. He never says rational basis scrutiny. He never says intermediate scrutiny. He just doesn't say. It doesn't matter. He does say there's a fundamental right for receiving a marriage license, which would suggest strict scrutiny, but that only applies for marriage licenses. It's not clear that that fundamental rights analysis applies for sexual relations by itself. So, I mean, if you had to ask me, Elena Kagan made him put the word fundamental, and he didn't want to do it, but Kagan's like, you have to put the word fundamental in here, so he listened to her, because she's very persuasive, right? But there's no fundamental rights analysis, right? Someone asked me in the chat about Glucksberg. I don't have time to talk about it, but Glucksberg would be the test to talk about fundamental rights, and he basically said we're not going to follow this. So I don't know. I think if you're asking about an exam question, you're asking about things as a practicing lawyer, I think you do the best you can. You say the level of scrutiny was unclear in Obergefell. It's probably somewhere close to strict scrutiny, but we just don't know. And if you're an exam, we'll be very happy if you write that. I'm giving you my honest answer. I don't have an answer for you. I think if you had to, Kevin, has your hands up. I'll get to you in a minute. But if you had to ask me, what will the new Roberts Court do with Obergefell? Right? They're probably going to treat sexual orientation like sex classifications. They'll probably say, the VMI case, U.S. versus Virginia, right? That's going to be the standard for sexual discrimination, sexual orientation discrimination. I think that's what the court will do. It won't be strict scrutiny, but it'll be some sort of intermediate. That's just my prediction. What do I know? That's equal protection. What is the court going to do with due process? I think they killed this entire dignity thing. I think it's just done. I don't think there's 5 votes for it anymore, and not even close. I think there's 3 at the moment. Maybe, 3. I think the court goes back to the sort of Bowers and fundamental rights approach, and they say we look at history, and we'll just say Obergefell is a one-off, and that was a deviation from precedent. You're not going to overrule gay marriage. I think it's not tenable at this point, not even trying. But I think the Kennedy model will be buried with him. I don't think it has much longevity. Kevin, your hand was up a minute ago.
Oh yeah, you kind of answered it. I was just going to kind of tag along with that last question that even though Kennedy muddied the waters, the framework is still very much good law, like all of the scrutiny tests and everything.
I think Justice Kennedy never formally abandoned the tiers of scrutiny. So they're sort of just like, lurking in the background. And I think it's going to be very easy for the Roberts Court to just pluck it up. To say, oh, well, we're using this framework. It's been around for 40 years. There were a couple of cases that didn't use it, but we don't worry about those.
Because from reading, it doesn't seem like there's anything that really they move away from it.
They don't Kennedy doesn't formally abandon it, which is important. He just doesn't apply it. And I think that had Kennedy said we are no longer using this test, that would have been really significant. I don't think he wanted to do that. He just doesn't like doctrine. That wasn't what he did. He didn't care about doctrine. He didn't care about tests. He didn't care about frameworks. He cared about dignity and making people feel they can define their own existence and their own ways of life. It's just that's what he did, and that's where he is. James asks for a 2020 question. Are we dealing with the court with Justice Barrett? Yeah, the court has is presently constituted. That's what we have. Justice Barrett hasn't decided any cases yet, but she might buy the exam. They usually have an opinion the first week in December, so she might actually be on it. I don't know. Usually they haven't decided any cases yet. We're usually first week of December before Christmas. They should have at least one case, but it might be till January this year. They might be pretty busy with some other things. All right,
Professor Blackman, I have a question then.
Yeah, James, go ahead.
Okay, and so with the modern makeup of the Supreme Court, it seems like a lot of these cases are now not on the same ground as cases we've very recently read.
Yeah.
So do we take account of that?
That would make for a very good exam if you do. If you're able to actually reflect the fact that this doctrine's not stable, like June Medical, the case we did yesterday, June Medical casts serious doubt on the whole woman's health. And I think if you can put that in your answer, I think that's a very good answer. Does that answer your question, James?
Yes, sir. Thank you.
My pleasure. What else is on your mind, guys? All right. Going once. Office hours in about 10 or 15 minutes. Going once. Going twice. Thank you all so much. I will see you all soon.
Thank you, Professor.
Thank you so much. Take care, everyone. And then